Good evening, everybody. We just want to wait a couple minutes for everybody to sign on. It just takes a minute or two for everybody to get on Zoom, and all the final reminders went out. So I know a couple people will join a couple minutes late, but we just want to get most people in before we get started. We had a decent amount of people sign up for this too. A lot of people are studying for boards now too, so I'm sure a lot of people will catch this on the rewatch. It'll take us a couple days to get this on the Club Derm website, but just check for it if anybody wants it. We'll have the link on social media too, on at least definitely on Instagram, that's for sure. All right, looks like the numbers are slowing down. Well, welcome everybody. If you don't know me, I'm Kim Campbell, and I run the Dermatology Authority and also clubderm.com. We are thrilled to have you tonight for tonight's webinar. We're going to talk just a little bit about job market trends. The hot topic that, we got so much feedback and so many people wanted to hear about was, updates on employment contracts. We have people that are going into employment, a lot of people going to fellowship, people starting to change their jobs, starting their own practices. So, we wanted to get this topic covered and updated. This is brought to you in partnership, empowered by our great partners at Club Derm, which is La Roche-Posay, CeraVe, Nutrafol, and Vichy are also partners, but La Roche-Posay and CeraVe are our main partners. Tonight, I am joined by the Ron Lebow, the healthcare attorney, who's done thousands of contracts and specializes definitely in dermatology. He'll talk more about his backgrounds when we take a deeper dive into the contracts. I'm just going to kind of go through a little bit before, some things to think about while you're making these decisions of, these are really, really, really important. And, I worked with Dr. Elston, and these were the three things that he said that, you should really consider before you start looking for your job, or if you're going to be starting your own practice or your next career move, is obviously location. We'll go into, some details on that. What type of practice? What scope of practice? What do you want to work with kids? Do you want to do cosmetics? What type of patients do you want to see? What type of niche do you want to be? Well, these are the basic type of practices. We'll touch on the differences between the contracts when we get there, because there's, a lot of differences between the academic and private practice. And then, now we have multi-specialty and corporate. And then the practice management partners is a whole, another ball game. So this is what we get all the time. Where are the highest paying salaries right out of residency? Well, these are the states where you usually get the highest base salary. Because some of the larger metropolitan areas, you can make a lot more, but then you're not going to get that big salary because there's just too much competition. So we also had some interesting facts come out. It was a recent article that Wisconsin was one of the best places to practice. Texas, Georgia, Florida, and North Carolina. I'm sure Florida has, because there's a lot of skin cancer, so if that's an interest of yours. And then South Florida, has a lot of cosmetics. A lot of people are moving to Texas as well, and North Carolina. So I think why they rank so high. Now, these were the highest wages from 1 to 7 years. Medscape has a great tool on their website. If you Google it, or I can try to put it in the link later, that will show you, based on what, where you are in your practice, and then, what state you want to live in and what specialty. It'll give you some good stats on salary and where you are. So Chicago being, number one, Houston, Texas, San Francisco, LA, Philadelphia, New York. But there's big differences, but then you have other things to take into consideration. You may make the most in those cities, but they also are very expensive to live in. As Ron knows that, I know that from being in New York. Yeah, so they're definitely much more expensive than living in Houston or in Pittsburgh. But the good news is no matter what practice setting you're in from, your first couple of years in practice, the more you practice, the more you're going to make. So, working the same hours with the same patients. So that's good news. What else we got here? So this was a really interesting article too. That was in the JCAD. So I'll definitely put this link in here because this was great. So it really shows where the dermatologists are per 100,000 people. So, if you think about supply and demand, you'll be busier in the places where there's less dermatologists and more people. So you can see where like another Manhattan with 30 dermatologists per 100,000 people. That's super high. Santa Monica used to be even higher than that. So you can see, where the dermatologists are per people. And, you'll be super successful, where there's less people, less dermatologists and more people. So when choosing a practice or practice location, those are things you really want to take into consideration. And then also, because you're going to be making a significant amount of money, that you're going to be paying taxes. So these are the two charts. We're going to post these on our social media too, because we found this very interesting. So these are individual. So if you're an employee, these are the taxes you're going to pay. And then if you start your own practice, you're also going to have to pay your corporate taxes. But there's also a lot of perks to doing that as well. And now this was really interesting too, comparing employed dermatologists compared to those that have their own practices. And I really think it's, probably a lot higher, but for the self-employed dermatologists, it's because they're able to write a lot more stuff off. So they don't want to really, put that as like, that's how much that they're actually making, because they're putting a lot of things through the business expenses. If you're interested in starting your own practice, we have tons of resources. We have a free practice startup list, and we can connect you with all of the people. We just did a webinar on that pretty recently with Dr. Patel and Dr. Given. So you guys may know that. So let's get into the good stuff and the stuff that you really want to hear about. So
right, Ron, the good stuff. Okay, so I've been practicing for over 20 years, and I represent employers who are hiring you. I represent people that are seeking employment. I represent groups that are buying and selling. I represent private investors in the derm space, which is big, and a lot of people are gravitating towards that.
Lab space
but
too.
It depends on what type of lifestyle and what your future holds for you. So I'm going to go through some of the terms. Now, if you have questions, identify the topic of the question. We will read questions at the end, and if we go over, we can go over a little bit. But let me just start by saying that, most 90%, maybe 80% of people don't negotiate their first employment agreement. They're afraid they'll lose the job. They're excited about the opportunity. They're afraid they'll come off picky or difficult or not interested, and that somebody else who's willing to sign more quickly will get the job. Everybody negotiates their second contract, because these contracts, when they're written, I'm told to write them. And I'm told to write them by the employer who's hiring you. And they tell me a few things: your name, your home address, your start date, your salary, and your benefits. And that's it. And I give them, depending on the client, a 5 to 30-page document that is meant to do one thing, and that is to screw you over. Because this contract has got a lot of legal mumbo jumbo, but my client's going to get mad at me if they want to get rid of you, or they want to change your schedule, or they want to move you to a new location, or on the way out the door, you're walking away, they can't stop paying you. They look to me as the person to blame. So I have to write a contract that's incredibly unilateral. Now, larger groups they got used to this. I'll get a lot of contracts that are fair. And the reason they're fair is because they've been negotiated by people like you over and over and over again. So they may be less willing to negotiate at some point if they've gone through that process. Smaller groups, same thing. Some of them are very fair. They'll give you a one pager and Ron, I got a one pager. It's got nothing bad in it. This is great. Well, it's what it doesn't say that's bad. So it's got to have things added to it. A solo, a lot more nervous, especially if they're bringing the first person. So you want to use kid gloves in a sense, but they want you for a reason. They want you so they can work less. They want you so they can make money on your head. They have capacity that you can fill or a specialty that you can provide that they don't. They don't want to send patients out the door. They need help. You have leverage, okay? The worst they can do is say no. So going into the topics, first topic, term. People come to me, the most important thing is I want it to be a 3-year contract, or I want it to be a 1-year contract and I want it to expire. It's irrelevant. Term is irrelevant because what's really relevant is how much notice they or you can give. So if the contract says they can fire you on 30 days notice, then it's a 30-day contract. Doesn't matter what the term is. Or if the contract says it continues in effect and never ends, well, until it's terminated, then it's the notice period that matters, right? If the contract's got a set term of 5 years or 3 years, or it just continues in effect until somebody pulls the plug, and you're saying, I don't want to lock into that same rate for the next 3 years, well, I'll talk about that. But contracts can always be negotiated later. You've ingratiated yourself to both the employer and to patients. You brought in business. Now you have more leverage later. That doesn't mean you don't have leverage to start, but you have less, certainly. And if you're joining a group and you're already started your own practice and you're bringing people with you, you have a lot more leverage. But term is irrelevant. Termination is what matters, okay? The only part of the term that matters is if partnerships can ever happen. And so you might want to just say, look, indicate when that's going to happen, and then we'll get into that at the end of this. But term is irrelevant. Termination is what's relevant. And mainly understand termination is a severance discussion. It's not really a notice discussion. Most people that give notice of resignation, I tell my client to walk you to the door. I don't want you bad-mouthing the practice. I don't want you giving your card to patients. I don't want you telling them where to reach you on the down low. I don't want you soliciting other employees to leave with you. I don't want you stealing patient contact information or records. I'm going to walk you to the door that day if my client's amenable to it. If you're paid on a salary and it's a 30-day notice period, that means that you're going to get 30 days pay even if they walk you to the door, unless the contract says they won't, which is what I write. So keep an eye out for that. If you're paid purely on a percentage or a part of your compensation's based on a percentage, well, then you want to be very cognizant of whether or not they have a guaranteed minimum schedule, because if they can change your schedule on the contract, the notice is irrelevant. They could just cut your schedule, okay? And they won't be in breach. If you're paid purely on a basis of a percentage and they walk you to the door, there is no base to keep paying you while the notice period runs. There is no continuing pay. There is no severance, so to speak. What you want to do is you want assurance that if they keep you around, your schedule is going to remain consistent with your prior schedule. So you know you can earn the income over the next 30 days or 90 days or 60 or whatever they require to negotiate. Typically partnership at 6 months to a year notice. Employment anywhere from 30 days to 90 or 120. Anything over that's unreasonable if you're giving notice. So, in terms of pure percentage deals, you want it to say that if they keep you, your schedule is consistent. The flip side of that is if they walk you to the door, which is fair, that they pay you lost opportunity income while that 30-day period is up. In other words, they look at the past 3 months or they look at the past year and they just average what your daily rate is, what your daily take home was, or daily generation. And then whatever period short of the notice they let you give or provide to you before they walk you to the door, that they'll still compensate you for that lost opportunity, okay? Locations. You join a practice, you know how many locations there are. Okay, you're set. You like the locations. Well, a practice that has 1 location today or 2 locations today may have 6 tomorrow. Practices merge all the time. They may sell to a VC tomorrow and assign your contract to them. You might not leave because your covenant may be terrible and you might like the money or you might like the people you work with. In any event, location specifying where you have to work, how often you're at one location versus another, whether one's primary versus one's secondary, whether you're in X location on Mondays and Thursdays, the other location on Tuesdays and Wednesdays. Or, they have plans to open a new location. It's closer to your home. You want to work there. Get in the contract that once that location's open, you have first dibs on it before they hire somebody else to take that spot. You want to be very clear what your location is, because I've been called and somebody says, oh, they have a new location. Now they want to relocate me. Do I have to work there or will I get fired? Yes, you will get fired if you don't, because the contract says you'll work at any office I require during any hour I require, period. So you're in breach if you don't listen. Go ahead, Kim.
I have a really good recommendation on that. If you really want to build your practice, only work at 2 locations, and you have to work at least 2 days a week in the same location. Otherwise, you're never going to be able to follow up on your patients properly. You'll end up leaving and being really unhappy. So we really highly recommend to do 2 locations at least 2 days a week.
And the locations that you're working in tie directly into your restrictive covenant. Now, I'll talk about restrictive covenants later, but understand that if we are able to negotiate that the covenant only applies to where you primarily work, either based on hours on average over the last 12 months, as opposed to where you worked 2 years ago and then you're at a different office, it should only apply to the new one. Whatever the scope of the geographic radiuses of the covenant, depending on the enforceability in the state, keep in mind that you want to be able to stop them from sticking you somewhere where you may not want the covenant to apply. So specifying locations is a no-brainer. These are all benign requests, all benign. And if they're not willing to commit it in writing, that's a problem. If they say, trust me, trust me, trust me, the person who's making those promises to you today could be a different person in charge of those decisions later. CEOs come and go, people retire. At the end of the day, you want to lock it up so that whatever happens in the future, you're not taken by surprise. Comfort is king, and you have the right, and they should have the obligation to give you that comfort, okay? And if they're not willing to, then they should provide an explanation at least. Outside activities, all the contracts I write, purely unilateral, say that you will not work for anyone else or earn any income, whether it's business related, healthcare related, medical related, dermatology related, or otherwise, or whether it's a speech, writing, research, directorships, product development, consulting, legal consulting, whatever is your bag, whatever you want to do on the side, my contract says that money belongs to me, my employer, period. So you got to carve out the outside activities you want to engage in. If it applies across the board to any type of business endeavor, it should be limited to medical related, or even better, dermatology related. If it applies to anything else, intellectual property, if there's an intellectual property clause that says anything that you develop or conceive during the term of your employment belongs to them, well, it should matter whether or not it's on their behalf. It should matter whether you're using their resources, whether you're using their time, people, staff, supplies, equipment, patients, whether you're doing it in your own time or whether you're doing it on their time. These things need to be thought about now. If you have plans, specifically, it's easier to get a carve out and permission. If you don't, then we can list a bunch of things that you're allowed to do in your own time, so long as they don't interfere with your duties, you ensure malpractice coverage, and you report when you're required to report, and you provide coverage when you're required to provide coverage, and that you don't use their resources to develop any intellectual property, right, or otherwise.
Are you seeing that come up more? Because with the academic institutions and the hospitals, even though like you're kind of working in a private practice with some of the hospitals, they're really strict with at least I've been seeing that with the recruiters.
Academic institutions and hospitals all have a conflict of interest policy that you have to follow and has to go through approval processes. You can get those processes started before you sign the dotted line, but they still want to go through that process. Private groups, VC owned, you can negotiate these things, okay? But you want to be very clear about whether you can work somewhere else and whether that money belongs to you, because mine have a catch-all clause that says all money earned belong to them. So you got to carve out both things.
What if you're doing like advisory boards, or you have your own skincare?
You've got to mention it. Specificity is king. If you know, If you're already doing it, even better. But if you have plans to do it, then you tell them you want permission out the gate. You don't want them cutting you off the knees to earn outside income, especially if they're not paying you enough, or if you're only working there part-time, especially. Now, if you're going to moonlight or provide services at a different location, you don't want to just carve out the other location that you've decided to work at part-time, 2 days here, 2 days there. Because what if you lose that job? Instead, you want to be a little bit broader. I'm allowed to work outside of some catchment area that's the practice services without your consent. I can go across the river, I can go 5, 6, 7 miles away, and you have no say in it. But if it's within your catchment area where you get your patients and referrals, depending on the geographic region may affect the size, then you want carte blanche authority. Within that area, that catchment area, it's completely reasonable for them to want to provide prior consent first. Okay. Now, if one's academic and one's medical derm and one's cosmetic derm, it's easy. It's easier. You could say I could do cosmetics somewhere else, do medical for you. That's a little bit more amenable to them. But if they plan on adding it, or they plan on hiring you just for that, oh, I'm a cosmetic practice, but you're here for the medical. I had that happen to somebody who said, please provide assurance in the contract that I get to do as much cosmetic work as comes in the door as you do, owner. Or if somebody requests me by name, you guarantee that they'll be scheduled with me or given the opportunity to wait my return if I'm not available, unless they elect to see somebody else sooner. You want assurances of assignment, but it's easy to convince them that certain outside moonlighting is okay. You can sit, as long as they know it's not going to eat into their own salary, their own income. It's easiest ways to do that. One is you assure them it's outside that area. Two, you contractually offer that you won't divert patients to an alternative location if they provide the service. Done. And that if you do, they're entitled to that outside income earned or some penalty for it, for the lost income, which is what I put in. I put in a penalty if you divert.
Okay, this is a little bit off. What about like if I'm doing like working with a brand on like social media, and then I'm gonna get paid to do some postings or something like that.
You're impacting their brand. Your face is their brand too. So in some cases, it may be a side gig, but we might covenant not to let that side gig market you specifically, because we don't want to pull patients who like you or patients who find you away from their practice. But it's all based on individual factors, but there are ways to soften them up. That's for certain. Okay. But don't just commit to certain outside activities. Try to broaden it and broaden the consent. And if they say no, if you want to make more money, we'll give you more hours. You got your answer. They explained why they're not willing to do it. Now, the question is, do they have the capacity? Do they have the patience? Do they have the equipment? These discussions should take place. Expectations should be clear. Okay.
One last thing on that too.
Yeah.
Because I personally feel like every dermatologist should have their own website, and whether they're working at and have the practice's information on there as well. How do you handle that? Because each dermatologist is really their own brand.
Do it. You can do it no matter what without even telling them. But at the end of the day, if you want to use any of their before and after pictures, you do need their consent. That's their property. It's information. It's material gleaned in the capacity of your employment. It's a good way to get around non-solicitation clauses, because if you're just posting things on your own website or your own social media, they're not going to win a solicitation argument. Okay. So there's covenants that say don't solicit our patients either during the term for outside activities or when you leave. That basically means don't steal our lists and use them to contact people. But if you're passively making announcements to whoever followed you on social media, they can't do anything about it.
And how much trouble do you get in?
Because I know people do that. People into leaving. Yes. Go ahead.
I know people do that when they're leaving and going to another practice. How much trouble can you get into?
Well, if they have more money than you, then from a legal perspective, they can punish you with legal fees by making you hire somebody. If they sue you, they can make your life miserable. I coach people on how to deal with the situation if they're leaving and they anticipate people following them, what to say, what not to say, when to say it, how to promote it. But if you don't even need a contract. If you took patient contact information with you, there are causes of action for that are outside of contractual causes of action that have nothing to do. Breach of fiduciary duty is one. There are other things they can bring against you, and it's hard to prove. Okay,
but it's easier now.
There's a trail for everything. And getting an injunction against you from doing things which would affect your future work and upset a future employer. Yes, go ahead.
Yeah, I mean, there's so many ways to track things now too. Like, I don't know. I would
Yeah,
say,
there are ways, and one thing that's funny came up with is reviews. I had somebody who worked with a practice for 10 years. They had all these positive reviews that related to both the practice and the individual. ZocDoc actually transfers all the reviews based on MPI, not based on group that's paying for the ZocDoc account. Don't just, you have a way to relocate reviews, but be careful about stealing any intellectual property. Now, some people will agree to let you use before and after pictures, even when you leave, so long as you credit them. That can be done through a watermark, or at least identifying that it was while you worked for them. And obviously, it's only for patients you personally treated. This is both videos and photos, but you want to address all these things because the point of the contract is to gather dust and only get pulled out when there's a problem. Okay. Do you guys know the different types of malpractice coverage? I can't hear you, so I'll assume some people do, some people don't. I'll get to compensation at the end because that's the most important to everybody, and then we'll have some room for questions. There are two types. There's claims made malpractice, which means so long as the policy is in effect during the time period that the claim is brought, you'll be defended. That means when you leave that employer, the policy is essentially canceled with respect to the employer. Either the employer, if they arrange for it, will do it, or you're mandated by contract to arrange for it and do it. That means that once the day after you leave, if you're no longer covered, if the coverage period ends, you're exposed. Your personal assets are it's exposed, depending on the state law protections and whatever trusts you've set up. But claims made is less expensive for that reason. So what do you do about that? Well, the other type is occurrence coverage, which means that so long as the occurrence giving rise to the claim happened while the policy period was in effect, you're covered forever, at least so long as the statute of limitations still applies. So occurrence is a lot more expensive. If you're Mohs, you want it. There are other, depending on what your specialty is, you may want it. But you typically, what you have to do to convert a claims made policy into occurrence policy is you have to buy what's called a tail. Now, one alternative to that is called nose coverage, which means you retroactively date your next policy to the origination date of the original policy, and it just charges you the premium. So if you leave, you have a claims made policy and you've been in a practice for 3 years, you go to another practice, it's year 4. If you get nose coverage, you're going to start at the year 4 premium rate without having to pay a big chunk of money, which could be 5 figures or 6 figures for a tail. Now, you may be able to get your future employer to cover the tail for you, especially if they're a hospital or a VC or a large group, but they're going to attach strings to it. The strings are, you got to be with us for at least X number of years, and we'll lend you the money and we'll forgive the debt over time. That's kind of the kind of strings we're talking about. All right. But buying tail can be expensive. You only need tail if you're going to leave the state, if you convert from claims made to occurrence, in which case you have to buy the tail for the occurrence period. And that's going to happen every time you go work for a hospital or an academic center. They're going to want to make sure that you have that tail because they're typically self-insured. They may maintain claims made in their own policy, but they mandate tail. Or if you go work for somebody else and they require occurrence, then you're going to have to switch from claims made to tail and buy the tail. So you want to find out in the contract what type of policy is and who's going to pay for the tail. Now, there are ways to negotiate that. If I'm with you for X number of years, you pay for the full tail. Or you pay for the tail if you fire me without cause, and I pay for it if you terminate me with cause, or I resign. Or every year I'm there over a course of 4 or 5 years, you contribute towards the tail. So if it's a 4-year period, you pay 25%. If I've been there a full year, you pay 50, they pay 50. If you've been there 2 and so on, you can get the drift. But always try to get them to commit to covering tail just in case if they're not willing to commit to the type of coverage. Now, if it's a practice area, if you know you're going to leave the state, you're probably going to need tail. In that case, you might want to price out the occurrence coverage and maybe contribute to the cost because the risk is higher for you, okay? Restrictive covenants are, can be crazy. It can be insane. It's going to apply to every office of the practice. There's one office today. There's 10 offices tomorrow. Which one does it apply to? Well, potentially every office of the practice. Most states that haven't outright outlawed restrictive covenants don't prevent them from being enforced. The states that pass legislation instead say, well, it can't be more than 3 years after you leave. And it's got to be specific in geographic scope and not too loosey-goosey. So there are ways to still impose restrictive covenants on you, but don't agree to a covenant you're not willing to live with, and don't try to negotiate it. Don't not try to negotiate it up front, because in any event, unless the contract says you're going to get your legal fees, if you win, and me as a lawyer huffs and puffs and says this is an unenforceable covenant, I'll go to court and get thrown out. Guess what? You're still fronting legal fees. You think you could spend years in litigation with somebody who can outspend you? No, you're going to go bankrupt. And beyond that, your future employer is going to want to know whether they're at risk, so they can be sued for interference with contract. You might not get a job. So even if you think it's a crazy covenant, I'll just get it thrown out. Think again, you're going to have to spend a lot of money. You may not have other opportunities. Okay. And so you want to negotiate the geographic area to apply to where you are, where you're working on average over the prior 12 months, or your primary office, maybe not other side offices that you cover occasionally. You might want to try to carve out academic work, or if it's a medical practice, cosmetic work. There are ways to loosen it up. Now, what you want to at least get is a honeymoon period that says we're going to test each other out. And if either you or I give notice within a certain period of time, I haven't been there long enough to threaten your practice and steal patients. So let's come up with a honeymoon period. I can move on with my life. Now, a lot of practices will be okay with that. It depends on whether or not, how much notice you have to give, because if that honeymoon period's too long and you still have to give 3 months notice, you may have a full year honeymoon at the end of the day. But so what you want to do is you want to try to massage how much honeymoon you get and under what circumstances it applies. You want to try to ask them a couple of things that they may never agree to, that I certainly wouldn't. But okay, if you fire me for no reason, it doesn't apply. Well, most people fire people for no reason without cause. They give notice because you don't want to litigate breach. It's not a good thing to litigate. It's time intensive. It's expensive. So most people are going to fire you without cause. It doesn't matter you're fired without cause. If you've been there long enough, you're a threat, you're a threat, you're a threat. Another thing is something that's a lot more common, which is if you sell to a VC tomorrow and I joined you and I thought I was going to have a different life and have partnership rights, and I decline to continue with that VC, it doesn't apply. A lot of times I get that agreed to because they just don't think it's going to happen to them. They hate them. They don't want to do that deal. But money changes everybody's mind. So at least try for that. Okay. Remember, the covenant protects the value of the practice. If you can move into the same building or across the street and take patients with you by mere proximity, and you have a business listing on Google that's free, well, you're diminishing the sales value of the practice. So they won't agree to it for that reason. Okay, another thing is if I terminate because the practice breached, well, the only real breach a practice can engage in is not paying you. Okay, and you still have rights under law that are going to at least give you benefit, get your legal fees back if you're chasing wages. But you want to see what things you can carve out, like I said, academic or certain type of specialty services. And everything's negotiable. There's always a way to make them feel comfortable. And a lawyer who does this knows what's common and knows how the employer thinks. But you want to negotiate the covenant. Believe it or not, they're enforceable in a lot of states. And believe it or not, somebody could even say you can't do the whole county or the whole state or the whole city because that person is so well known. They draw people from all over. They're looking at whether it's reasonable in court. If that person draws people from all over the city or all over the state or all over the county, they're going to get away with a lot larger covenant. And if they're advertising a brand name at 10 different offices, they're going to get away with a larger covenant. So negotiate it. Don't count on it being thrown away and poo-poo it. It's a bad way to go. Days and hours. When am I working? How often am I working? What are my hours? What's my own flexibility? Are weekends required or nights required? Is it a certain number of average hours per week? Do I get to pick the hours? Is it every Monday and every Tuesday, 7 to 6? Tell me now. Put it in the contract. My contract I write says you're going to work the hours I require, period. If I'm paid pure percentage, like I alluded to before, you want minimum guaranteed hours because you want an assurance that you're going to still have a schedule. Days and hours is a no-brainer. They should have an expectation as to where they want to place you or what they need you for, whether it's going to be one Saturday a month or none. You need to set that up front. And whether or not you can switch the days at your own discretion, so long as you give them X number of notices to schedule. And beyond that, you might want the right to work more if you want to make a little extra money in a given month. Put in the contract. I should have the right, as long as the office is open, to come in whenever I want. I might want to accommodate a very special patient on a Saturday. Get that unilateral right in there. They're going to be like, great, we'd love you to work more. No problem. We'll write that in. Now, these are all benign requests. You're signing a document. They had a lawyer write it. They paid the lawyer thousands of dollars to write it. They're not going to be surprised you're trying to negotiate it. Dispute resolution. This is the big one. All right, you got two types. This is the big one that can come back to haunt you. Arbitration versus litigation. VCs or hospitals or groups with a reputation want arbitration clauses. It keeps everything silent and private. It's not public information. Nobody gets to hear about it. The resolution's secret. There's no publicly filed lawsuits. There's no back and forth. There's no PR threat. Try to get rid of an arbitration clause whenever you can, because threats of litigation are more effective. Arbitrations can be just as expensive, if not more, than litigation in some cases, and they're almost impossible to appeal, while litigation you can appeal at the very least. You also want a mutual attorney's fee clause so that whoever wins an action gets their attorney's fees reimbursed. Now, I claim when I negotiate against the employer, that's meant to disincentivize somebody from bringing a baseless action they know they're going to lose. They have to pay the other party's legal fees on top of their own. They're not going to bring it. They're going to come to the table and negotiate. All right. But what it really does is it evens the spending playing field, because if they can outspend you and you have a clause that says they'll reimburse your attorney's fees if you win, they're not going to want to try to outspend you, especially if they know they're going to lose. So it evens the playing field on that basis. Partnership. If you really want it to happen, or even if you don't want it to happen, ask about it, because then they'll think you want it to happen. People go work for people and say, oh, I know I'm going to leave in 3 years. I just want to learn something and then start my own practice. So what? Ask for it. It's at least something you could give up during the negotiation. Say, fine, you don't have to commit to when partnership's going to happen. You don't have to commit to what the terms are. They may already know the terms. They may have a process. They've done it before. They may know whether there's a buy-in, whether there isn't a buy-in, whether it's equal or vesting ownership over time, whether you're going to get a piece of the separate med spa entity, or whether you're going to get a piece of the lab, or whether you're going to get a piece of a separate management company that manages the practice, where they're paying themselves expenses and putting money from one pocket into the other and decreasing your share of profits. They're going to know whether they're going to take your buy-in pre-tax, whether they're just going to offset it from your distributions so you're not paying with after-tax dollars. In other words, you don't have to run to a bank, or you get 50% taken out of your payroll, and now you got to go find the other 50% and give it back to them. You're paying more than you really earned. They're going to want to, whether or not there's real estate play. These things can be dealt with depending on the circumstance. Or depending on the practice's willingness, but at the very least, they can at least commit to you when and if they're going to discuss it. Now, that's an agreement to agree. It gives you nothing, but at least it gives you something if they go ahead and sell to a VC the day before that your partnership negotiations were about to begin. That's leverage, and that's something you can bring litigation against. Okay, let's talk about the big one: bonuses, compensation. You got your straight percentage. Well, you got to deal with what the advance is going to be, because depending on whether it's cash pay, cosmetic, or medical, there's a time frame to collect receivables. You might want to get an advance for at least 6 months, or whatever the ramp up period is. If you know you're starting a new office, it's going to take time to build it, and they're bringing you in to build it, or a new service line they want you to help develop. It's going to take marketing and time. Then they better be able to pony up a guaranteed minimum compensation or guaranteed minimum bonus in that ramp up time, usually at least 1 year, maybe longer. You may want to have a greater of alternative, where it's the greater of X percent and Y percent. Greater of X dollars guaranteed per year, prorated, or X percent, whichever is bigger. Or once I cover certain guaranteed minimum salary, it switches to full percentage with a guaranteed minimum schedule. Most of the time, they'll want to do a mix of comp, some baseline, and then a bonus based on earnings. The typical scenario is, let's say they're going to pay you $100 for the year. I'm just doing low numbers just for educational purposes. Well, bonuses are typically 2 to 2.5 times the base. In other words, they're going to say that you get a bonus based on your base is 100, so they're going to double it or do 2.5 times it, in which case it's 300. 250, and they're going to say everything above 200 or 250, we're going to give you a percentage for everything in excess of that. By doubling it or doing 2.5 times it, they're guaranteeing a take home from their self profit, they're covering their overhead, and they're ensuring that you have to hit a minimum. So when is that minimum? What is that minimum? Is it based on the whole year? A lot of the time when I write the contract, it's based on an aggregate amount of money. You have to bring it. You're not going to get a bonus till you hit $750,000 or $1 million, and you're going to get a percentage for every dollar above that number. Well, if you leave or they terminate you without cause during a certain period of time and you haven't even hit that number yet to earn a bonus, you want to address in your contract that that number is prorated, so that if you left halfway through, that threshold is cut in half and you get the percentage above half of the threshold, because it rewards your hard work through the last day without the rug getting pulled out from under you, particularly if they terminate you without cause. You may want to try to earn the bonus sooner. In other words, it's after the first quarter, they right size your bonus monthly, and it's a prorated amount. Or if they insist on it being an annual aggregate big number, then you have them give you an advance monthly or an advance quarterly. And then at the end of the year, they tally the numbers and determine whether or not they overpaid you or underpaid you and make up the difference. And they can offset it against future comp or have you give some money back if you're leaving. But you want an income stream. You want a higher income stream over the course of employment. You want to earn the bonus as often as possible in as short a time frame as possible. And you want to keep it. So, chopping up the thresholds is a good way to do that. Quarterly or monthly is not uncommon, right sizing. But I keep it annual when I'm coaching my clients because I want you to stay for the whole year. I don't want you to leave halfway through. I want you to stay for a year and a day. So timing and thresholds and all that are all up for discussion and negotiation. Your expectations should be made clear as to that. Always ask for more. Number one rule of negotiation, always ask for more. They may be lowballing you and have another set of money they're willing to offer if you just ask for it. If you're going to work for a VC or a large private group or a hospital, and there's no sign-on bonus in the contract, there's no relocation reimbursement, always ask for more. Is there a sign-on bonus? Don't negotiate against yourself. Don't propose a number. Kim and I can tell you what the typical numbers are depending on the type of employer, but you'd be surprised how many people are like, oh my God, Ron, you asked for a sign-on bonus. You didn't even ask for a number, and they came back and offered $35,000 on day one. Are they going to pay Are they going to pay it when you sign? Are they going to pay it 30 days after you start? Are they going to split it up? Is there a retention bonus that you're going to get if you're there for at least a year? You'd be surprised how much money they may be putting aside waiting for you to ask. Yes.
For the sign-on bonus, do you have to stay in like a certain amount of time to not have to give that back?
That's right. So usually they'll go for 3 or 5, and then we try to cut them down to 1. If they're going to tie relocation reimbursement, the cost of moving to that period, it really should be 1 year or no more than 18 months or 2, because you've incurred that expense. Sign-on bonus is sort of found money. So in that case, you might want to chop it up. Now they'll say, okay, you got to be there the full 3 years to not have to pay that sign-on bonus back. No. Prorate it for every month short of 1 year. No, it's got to be longer than a year. All right, so we go back and forth on how long it's going to be, or it's just a quick discussion and ask and answer. Maybe if they insist on no, we tie it to 3. That's our policy. All right, fine. 1/3 for each year. All right, if you're not going to prorate it per month or per day. And certainly if I'm disabled or dead, or you terminate me without cause, I shouldn't have to pay it back. Without cause, maybe a little bit subject to argument. But now here's where you leave money on the table when you leave, okay? Accounts receivable. If the type of practice you engage in means that the collection, it's going to be another 90 days for them to collect the money for the services you rendered during the last several months, especially if your pure percentage or your bonus is based on that period, based on a percentage, you want to get credit for the next at least 90 days, 6 months, sometimes even a year of the money that keeps coming in that they just didn't get yet towards your bonus. And they'll pay you some bonus initially after you leave, and then they'll right size it as more money comes in. But otherwise, you're working for free. I mean, I had somebody who worked percentage only, and there was no AR clause. And they said, what do I do about this? I said, well, there's nothing you could do. I mean, you've worked the last 3 months for free. I mean, what were you thinking? And then other employer, if they give you a minimum base, well, they front loaded your salary, right? They advanced it. So in that case, it shouldn't necessarily be longer than 90 days. Or maybe in their case, they might not want to give it to you at all. That's more reasonable if they front loaded your salary. but you want to be very cognizant of how they can keep money when you leave. And you want access to the books. You want a clause that says you have access to the books and regular reporting, that your accountant can look at it, including following termination. Now, forfeiture clauses with respect to AR are easy. I write in my contracts, I don't say, some of them are very express. They say, you're not going to get any AR credit. I don't write it that way because I want to trick you. I write it instead that you're only going to get credited for collections of the practice that come in during the term. I don't use the word forfeit. I don't use, you don't get any AR credit. Some explicitly say it, but if it just says credit, you're credited with collections that come in during the term, well, that's a forfeiture clause, but an underhanded forfeiture clause. So be very cognizant of the money you could be leaving on the table. It could be 5 figures. It translates into a lot. Confidentiality, we talked about. Other thing on compensation, when I say always ask for more, I mean it. I mean higher percentage too. I mean less costs coming out of the salary. They don't deduct, many of them will deduct expenses before they pay you the percentage. Is it just disposables? It's just fillers, injectables, laser tips, or they're trying to actually take people's salaries out of you, or lease payments, or overhead, or billing collection fees, or credit card fees. Some of those are reasonable, some aren't. But the cost deductions need to be ironed out and very clear, because taking more costs means they're taking less. You're getting less. So when I say ask for more, that means cut the cost they deduct and determine the order in which they apply the deductions, whether they apply it first and then pay you, or whether they come up with they apply the percentage to the total amount and then take the cost off. That actually offsets who's really responsible for the cost and whether they're sharing it. But if they say, no, this is our starting rate, I want a guaranteed base income in the next year, or I want the percentages to go up every year, or I want that threshold that you came up with to go lower, or I want it to be 50% across the board in year 3 if I'm still with you. It's always about asking for more. It never hurts. Try to get it up front. You can always negotiate later, but you got to be willing to leave and live with a covenant. Your only leverage in a contract is willingness to leave. I'd like to, let's talk about what you want to talk about, Kim, but then let's get to questions so we can get into any nitty-gritty.
This is super important, though. This is super important because, so, you're telling everybody to negotiate. You could change the terms, but the practices and the people hiring are getting upset because they're giving them, they just discuss this stuff and then they go and negotiate, but then they have to do, multiple contracts. So what's your advice on trying to get some of these things, agreed upon before they get the, actually the terms, before they actually go get the contract written especially for the people that are first time doing this, because they're like, oh, we agreed on this and this and this. And then, now they want this. It would cost a whole, a significant amount of money for the practice to have the contract rewritten multiple times. So just a little advice on how to handle that.
If they give you a term sheet and you don't have to sign it, and you say, go ahead, you don't agree necessarily, but you say, go ahead and provide the contract so I can evaluate all of it, right? You don't say yes. If they give you a term sheet that you sign, it's still non-binding. It's still dependent on you signing a contract, but they're going to be angry if you now have a lawyer and you start asking for things that you didn't want, that you didn't address at the term sheet stage. Start the negotiations with the attorney, but as a ghostwriter. You don't need to lawyer up in their minds. As a ghostwriter for you at the term sheet stage, when they put bullet points in an email or a piece of paper. Negotiate then, because if you try to change the terms at contract stage, they're going to be upset that you pulled one on them. Okay. So, and they may think that you're now bringing to them an offer that you received from somebody else, and maybe they're wondering if you're iffy. Always negotiate at the term sheet stage if there is one, and never agree to anything. Don't do it yourself and bring in a lawyer, because I'm going to tell you, oh, that was a really dumb thing to consent to. Let's ask for this instead. Or you could, there's a compromise that you didn't think of, and I'm going to tell you what that compromise is. If you agree to all these things and you tell them that sounds great, and suddenly a lawyer is in the game, well, they're going to think that I'm just putting the ideas in your head and that you don't really care. And they're right, I am, because I know a lot about it, because I've been doing thousands of them on behalf of groups I represent and on behalf of employees seeking jobs. With that, let's get to questions, because I don't want to lose any.
What to look for in contracts if you'll need maternity leave during your time there?
Well, depending on the size of the practice, will affect what your rights are for maternity leave. The smaller, they may not even be covered by certain medical leave laws. Okay, you have to have certain size thresholds. The larger groups, the hospitals, they already have maternity leave policy. That's it. It is what it is. It is. Find out what it is. Okay. Smaller practices, you can negotiate. Well, I'll only give you what the law provides. Well, the law may provide nothing if they're small and they don't have a certain number of employees. May provide nothing at all. In which case you say, well, I can use up any of my CME time, vacation time, and on top of that, I can get X number of weeks paid and X number of weeks unpaid but optional. And it may depend on whether it's C-section or vaginal. These are discussions that should take place. Now, at the end of the day, if it's a smaller group and they love you, they're not going to fire you because you're out too long. And there are certainly lawsuits you can bring, but not in every case. Again, it depends on the size of the group.
Okay. What about social media ads and or like if you're signing with what to look for with the company that you're not the employee, not the employer, but is there certain things you should look for when you're signing, with a brand?
I need more. I need to elaborate
Okay,
on
we
that
need more
question.
information on that.
Yeah,
So
if
like
whoever
if
wrote that can elaborate, we'll get back to it. So let's go to a different.
Okay. They want to know about the different payment models, especially for cosmetic procedures. Have you seen people negotiate this, or is it standard for everyone in the same practice, salary only collections, flat rate, etc.? Usually, at least for what I've seen, it's usually the same for everybody within the practice, unless somebody's been there longer and then they, as they grow, they've just changed it to all one fee. But everybody, or they have their own following, they may negotiate something different, but usually
That's
it's
true.
standard.
Now, it may be the same percentage for both medical and cosmetic, or it may be different. They may lower the percentage for cosmetic, but say, oh, but we're not going to offset any costs. Well, they're really doing it by lowering the percentage, right? They offset the cost just by doing that. So you want to ask them the numbers. What do you think? How busy do you think I'm going to be? Okay, give me projections. They know the numbers. They should be able to tell you how much your take home should be. And other people already know there's experience there. But there may be different percentages based on cosmetic versus derm versus Mohs. And then it's a matter of whether they increase over time or what costs and when are taken out.
Any recommendations on negotiating vacation, medical emergency?
Always ask for more. Okay, that's it. If they offer 3, ask for 5. In other words,
Okay.
you can make 3, 4 very easy. And the trick to make 3, 4 is just simply saying, well, can you carve out CME as separate from that 3 you offered me? Because the 3 may include sick, personal need, vacation, CME. No, give me another 5 days for CME. Or if I'm only working 3 days, give me another 3 days for CME. You just got an extra free week. Or you ask for guaranteed increase in vacation in year 2, or at least by year 3. And they may be willing to accommodate that at the outset.
Have you seen or do you recommend any types of provisions that can be made in a contract about job security, just in case they don't pass the boards? Even, there's a few people that don't pass every time. So,
yes, the common term, and it's industry standard, is you have 2 years. Some people only require the first time. Some people want, say a year. 2 years is industry standard for passing the boards. Now, remember, they probably can still kick you out without cause.
Okay,
unless there's a real partnership, term sheet attached to the agreement, or a real partnership track. Then maybe, I had a client who had to wait 5 years before partnership, and then they got the notice 4 years and 90 days to the day. Your term hereby let go without cause. You might want to say, well, if it's a 5-year wait, which is crazy, or maybe depending on the circumstance and the amount of money at stake, maybe not. But if it's a 5-year wait, you can't terminate me without cause after year 4. If I'm still with you, you got to give it to me. And I want to get a sense of whether you're going to ask me for $1 million or what it looks like, because I don't want you trying to negotiate terms that are insane just to get me to turn down the deal.
Any advice on practices that use you in their marketing materials, on who has a say on how these materials are used after you leave?
Only relating to whether or not you can use before and after photos and videos, whether or not you have to attribute it to the practice. If you already establish a brand and, through social media independently at the outset, do it. Just do it. I mean, the practice is not going to be against you trying to earn business. They want you to. They want you to have a good brand. They may want a right to review it and approve it. They may, it's their brand as well that you're affecting. So if you're saying things that they don't like, they might want to know. But you definitely want to just do those things anyway, no matter what. Deal with the fallout later because your career is your own, your livelihood's in your control.
Okay, these are some little bit more individualized. Should they specify how often they should get paid? This particular person will be working in a cash practice only, and they're not an employee, so they're going to be a 1099 providing professional services.
Bi-weekly or monthly?
Okay.
Bi-weekly or monthly?
Is it was the cosmetic percentage of expendables generally removed from the gross or from the employee net?
Well, that's the trick, right? Depending on which order you do it in, you may be pushing it onto yourself entirely. You want to make sure the formula works out so that they're sharing in the cost, not putting it onto you.
Okay, on average.
And not all contracts are clear. Sometimes the formula is clear of the order of operations, as you say in math, right? What's done first, right? Percentage then deduction, or deduction then percentage. That changes the number. If you're not clear in the language, make it clear.
On average, what's the industry standard for length of time you stay at your first practice? That varies. Talking about and getting all of this up front usually lasts. You end up staying longer if you address. The more you address and the more you talk and the better communication that you have, you usually stay longer. Ron, what are your thoughts on this?
I mean, it depends on what your future goals are. Whether you want to go out on your own, whether or not you just want to show up and work and make money, that's fine. No ownership opportunity. Whatever your future goal is will determine that.
Yeah, and people, think things change too. So, how do you ask for a guaranteed amount of patients in order to make a certain amount?
You can't, right? Instead, you got to get out there and hustle and then get a contractual clause that guarantees that anybody you do bring in will be assigned to you and not pawned off on somebody else, or worse, on a physician extender who you don't get credit for. If they're billing through PA or MP or otherwise, or using an esthetician or technician, the contract might not give you a credit for a dime of that, even if you're supervising the person. You want to be clear about what types of services you expect. And then you want assurances that if you have capacity, you might even have priority assignment. I had people who are Mo's and they go to work for a practice, but they're expected to do other stuff too. But we put in the contract that if the Mo's will be assigned to me, the goal is that I'm only doing Mo's. That's it. If it's there, that's what I get. And then when my plate's full, you can hire somebody else. You can't really tell them not to hire people, but you sometimes, depending on leverage, can say you won't hire somebody else in that specialty if I'm not willing to pick up more hours, if I'm willing to pick up more hours, or I still have capacity for more.
Okay. How do we figure out what a fair rate of collections is based on our area? Most of them are between 40 and 45% of collections, but most of them are right around 40% of collections. Are you seeing anything different, Ron?
I've seen 35 for the cosmetic where they don't offset the costs. I'm sorry, where they don't offset the cost, but that's just, so you want to run the numbers. You want them to run the numbers and give you an example. 40 is typically starting, 45 is typically top. More generous practices will commit to giving you 50 by some certain date certain.
Yeah. Okay. So for solo dermatologists,
that's rare.
Yeah. For solo dermatologists who built their own practices, how would you want a potential successor to approach you? This person is exploring opportunities to join a solo practice with the intention of becoming a long-term partner and ultimately buying out the business over time. What's the most thoughtful and respectful way to structure the conversation, and what type of arrangement would give you confidence in, what type of arrangement would you recommend?
Am I representing the employee asking or the employer?
The employee asking.
Right. So you want it to say when it's going to happen. Is there a buy-in or sweat equity? Is it buy-in equal? Do I get equal on day one, or do I vest ownership over time? In other words, I only own 10% year one and 20% year two, and then by, the fifth year, I'm 50, equal. At what point will I have decision-making say? Um, will it be offset from my compensation, my distribution, so it's pre-tax buy-in, or do I have to run to a bank and pay all at once? When is this going to happen? How does the buy-in work? How do you anticipate valuing it? Can we be specific about how you valued it? If you've done it before, contract can say simply, you're going to treat me the same as people you did it before with, or better, the same or better, not worse. And I had somebody use that language to sue somebody for $1 million, and they won because
Oh,
they tried to give them a worse deal. They formed all these other companies, and then they charged expenses to themselves. Like I said, they formed a management company, and they were just taking money from one pocket and putting in another. It decreased the percentage. They didn't give this person a piece of the management company, so they artificially deflated the profit share. That language said, you're going to treat me like everybody else. That meant I get a piece of the management.
okay. Would they be typically doing the contract negotiating with the employer at first, or like when is it done between the two lawyers? You want to talk about
Do it
that
with them.
process
First of all,
or the
you and the
best way?
lawyer both present all your comments and issues in writing at the outset. Do a comment letter. You say topic, section, blank, this. Collective front. And if they want to talk to you on the phone about it, the only thing you ever have to say is, that's important to me. That's it. That's important to me. I'm going to take notes. And then when we get off this call that kept my lawyer off of and your lawyer off of, I'm going to go back to my lawyer, or I'm going to go to my spouse.
Okay, so
And then I'll get back to you.
we have
And it
somebody on the
all
other.
flows through the lawyer, single point of contact.
Okay, so on back to the buying the practice. I don't know if this is the person, if they're both talking. On the other side, the person that's selling, how would they make it clear that they're wishing to sell the practice as 100% of my gross or maybe net receipts after 2 years?
It
This
would
is
say the
the
formula
seller.
in the contract. I mean, I can
Okay.
tell you, depending on the type of practice in the market, what the formula would look like to a sale to an associate. Now, the formula for selling to a third party, BC, is going to be 10 or more times the amount the associate should pay. There's no way you can
Okay.
match that money.
So this is our last question, but if you guys have any more questions, put them in real quick. How do you find a reputable lawyer? Are you available? And what is the roundabout fee for each contract?
Well, you're going to get a lot of lawyers that say, I'll do it for $500. You just, you're getting out of school, you don't have income yet. I mean, you're negotiating for a pretty, generous salary at the gate, but yes, you have loans. Somebody who says I'll do it for $500 is not going to give you the attention start to finish. You get what you pay for in this world. It's true. They might say, "Oh, I'll give you a comment letter," and that's it. But somebody who charges more will back and forth and hold your hand and walk you through it and negotiate and offer compromises and even go beyond and redline the document.
And that's important because you'll get the contract review just once, and then it doesn't go through the whole process. We've had that, and then they had to change attorneys, and then that holds up the whole process. I've had people lose jobs over it. So that
kill the process. You're not going to get somebody turn down an offer just because you make requests. By the way, that happened to me twice actually. The second time, the person was just, "I'm so insulted you asked for these things." Well, I mean, the contract was so heinous. It was so beyond industry standard. It was disgusting. And I told my client, I was blunt, most disgusting thing. The fact that the person says, "Oh, I'm so insulted you asked for these things." Do you want to work for this person? How are they going to treat you? They're, "Oh, come work for me. I love you." That hat goes away when the business hat comes on. So you learn something. And going through the process, you get answers. "Oh, can I work any day I want as long as I meet the hours?" "No, I need you every Saturday." Now you have an answer. The other time it happened, they said no to everything. They withdrew the offer. And guess what? I got approached a month later for the same employer and said, "Hey, I want to let you know what happened." I sent a request letter. It incorporated all the concerns my client had after I spoke with him, my legal concerns, the legal language that weren't cool. You're running the risk. They'll walk away. They said, "No, I understand why you asked for these things. These are important. I don't want to get screwed that way. It's not fair." Guess what? They agreed. I sent the same letter to the same employer, and they agreed to every one of them. Why? Turned out they liked my second client better than the first one. They didn't care about the first one. They weren't that hungry for that person. The second person was amazing. They were such a nice and personable, and they were already working on ways to market themselves. They got every single request. So, you know, in a career of over 20 years, you know, doing deals, 2 is not a bad number.
That's not bad. Do 1099 derms receive higher collection rate than 40 to 45 typically? Yes, but usually it's really around the 40, at least I see around 40, 45%. And if people don't want to go any higher than that, you know, do offer like negotiate like a threshold. Well, when I bring in $1 million worth of collections, then I'll go up to 47. You can stage it and people are more likely
Yeah.
to say yes to practices
If
are more
somebody
open to
comes to
that.
me and says, "Oh, there's a threshold of 3.5 times the base before I start to earn it," first I offer to lower. I say, "No, you got to lower the threshold. That's not an industry standard threshold." They'll usually go on that. They might offer a lower percentage at that lower threshold, but then when I hit that threshold, give me a little higher, and then when I hit another threshold, give me even higher
Yeah, because then there's less
in the
risk,
same
especially with
year.
the
In the
smaller
same year,
practices.
right?
There's less risk on them, so they're more likely to negotiate. You know, once you hit bring in a certain amount of revenue, they're more likely to give you more, just like you know
Yes,
anywhere else.
because
How
it
common?
could translate to another 10 grand, which is nothing to them. And if you've hit that number, great. They're
Great,
happy. They've already
Ev-
pocketed their
everybody's happy.
overhead and profit because they had a threshold.
Yeah, and that's what most of the private practices are. Then the smaller boutique practices are worried about. You know, they want to at least cover their costs, and
And
once
earn
they
a
do,
tiny and be assured of what their profit's going to be before they give you a piece. Yeah.
exactly. How common is it to have income based solely on percentage of collections versus mixed with the base salary? It used to like almost like 10, 15 years ago, most private practices were all percentage of collections. Now I see much more with a mixed base. How about you, Ron?
Mostly it's mixed lately. It used to be pure percentage, and then like that issue I brought up where they cut somebody's salary, or you know they only gave you credit for what came in while you worked there. That's what became a problem. They didn't have a minimum schedule. More often than not, you're looking at a mix.
Okay. You mentioned it's okay to post about your new practice on social media and it's not a violation of non-solicitation. Is this okay to do while you're still finishing up at the old job, final 60 days, or wait till you're finishing working there? Myself personally, I
If
would wait, but you
if
know,
somebody sees it, you're out that door. You don't want to do that. Now there's some states, including New York, where I'm based, or New York City, that outlaw even looking at employee social media. So that could be helpful. But yeah, they'll find out, and you're gonna be walked.
okay.
And now
The
you've
other,
made an enemy. You've made an enemy where you might have departed as friends. And
unless
maybe they even
they
support each
approve
other
of
debtors.
that,
They're like, good, I'd love to work with you or refer to you if, you know. So
yeah.
don't make any, you know, don't burn bridges if you can avoid it.
And it's a very small world in dermatology. Everybody knows everybody. Like
Yeah.
at least, especially too, when people are interviewing and they're giving you contracts, please follow up with people because if you ghost them, you know, you may want to go work there. Just get back to them. You know, the people that you are talking to could be friends with that person, and you know, everybody knows everybody. How flexible
Sometimes
are
it's the flip side. Maybe everybody knows that the person you work for sucked, you know, and
that
they don't
too?
blame you, right? So just be aware of the perception.
Yeah. How flexible are contracts with academic practice as compared to private practice? Private practice, you have a lot more flexibility. It really depends on the academic institution. The bigger it is, usually the less flexibility.
100% agree with that point. Although you can always negotiate bonuses and whether or not, you know, forgiveness periods for if they're paying you loans to cover tail or relocation reimbursement, or, you know, what the sign-on period is, and or minimum guarantees if they're trying to open up a new line or new area, new geographic area. You know, that you can money is where you negotiate, and even and the restrictive covenant too, you know, business terms, but make sure you're working with an attorney that understands the business and knows what to negotiate, because an attorney is not just looking at legal language. They should know the industry.
Speaking of, do you is there any states that like you can't work in when
I only don't do Connecticut and Florida.
Okay, so if they needed to do Connecticut or Florida, how would you recommend them
I
finding an
would,
attorney?
I'll tell, I could maybe send them, find somebody.
Okay, or you can contact me too. Well,
Yeah, and there's
yeah.
American Health Lawyers Association. They have a search engine of lawyers. They're health lawyers, right? Some are litigators, some are billing experts, some are deal attorneys, some are contract attorneys, some are employment lawyers. I mean, I'm not an employment lawyer. Don't make a mistake. I'm a business attorney in healthcare, so I do business deals and arrangements, and just this is a small subset of what I do. But
And
anybody who does deals and contracts and knows healthcare in that area, you can talk to and ask them a pointed question. Do you know the difference between claims made and occurrence coverage and malpractice? If they can't answer that off the top of their head, don't hang up the phone. And they should be
and
willing to talk to you without saying, "Give me a retainer first." That's not.
yeah, and
Well,
if there's, if you want to just, like, is this normal, or, or is this restrictive covenant, you can reach out to us as well. Because we work with people all
and
over the
I
country.
advise Kim, she'll pick up the phone and call me, "Ron, I've got this person asking about this," and I'll tell her, "Oh
What do
yeah,
you think?
this, that, yeah."
Exactly. We've worked together on a lot of things. And Ron writes a bi-monthly column on Club Derm with all different topics when it comes to legal situations that come up in practice, with contracts, and also with partnerships, and what happens if you get fired. We got tons of articles, that are really interesting. So I want to thank Ron for his time, and I want to thank everybody that that showed up and came on and asked questions. And if you have any other questions, feel free to reach out. I can connect you with Ron. I can connect you with whoever you need, to to get your goals accomplished. So that's all I have, and I want to thank La Roche Posay and CeraVe for sponsoring another Club Derm event. Well, good night. That's
Thank you,
it.
everybody, for attending. I appreciate it.
All right, we'll talk to you soon.
They should teach
Thank
you this
you.
in medical school. They don't. It's
They
insane.
definitely don't. They should, right?
Yeah.
Thanks.
All right.
Bye bye.